I've gotten a lot of questions from members of the public by email, and I want to try to answer as many of those as I can tonight. If I can't answer them tonight, I'll try to answer them in the future, but for those of you who sent them in, thank you, because it helps me know what I can say tonight that will be helpful to all of you in understanding what the city is doing. So one of the questions that I got repeatedly is, why don't we just close the airport? Well, as the city manager said, though the airport is ours, we own it and operate it. It is not leased from the federal government. Some of you ask that. It's ours. Though the airport is owned and operated by the city of Santa Monica, aviation in the United States is controlled by the federal government, by the Federal Aviation Administration. And that is why the city manager said that this was a particularly complex problem, because though we own it and operate it, what happens to it isn't solely up to us. If it were, this would be much easier. The council would hold some hearings, they'd probably be contentious, and then the council would just make a decision about what to do with our resource. But it isn't nearly that simple in the case of the airport. Let me explain why. The aviation in the U.S. is governed by a complex set of federal laws. I want to talk a little about those. The reason it's governed by a complex set of federal laws is that Congress has decided that it's in the national interest to have a functional national aviation system. And so the Congress has adopted a number of federal statutes. Those are all found in Title 49 of the United States Code. They include, among other things, the Federal Aviation Act, the Airline Deregulation Act, and the Airport Noise and Capacity Act. So because of the national interest in having a functional and even prosperous nationwide aviation system, Congress has created the FAA and given it the authority over matters concerning the use and management of navigable airspace, over air traffic control, over air navigation facilities, as well as over airport development. Generally speaking, the FAA has very broad authority over air commerce and safety, including the authority to promulgate administrative regulations and other administrative directives that limit our authority. However, federal law, the federal statutes, Congress, do recognize that proprietors of airports, which the city of Santa Monica is, have proprietors' rights. Part of our problem is that the Congress didn't say what proprietors' rights are. So that has been left to the courts, which are still sorting that out. More on that a little bit later. Quick summary of laws that were enacted by Congress. And the last thing I told you about that was that Congress gave the FAA the power to adopt regulations. And boy, have they. The FAA has promulgated extensive regulations. Those are found in Volume 14 of the Code of Federal Regulations. Most important to us lately have been Part 16 and 161 of those, which have to do with what federal grantees can do and have to do with implementing the Airport Noise and Capacity Act. But it isn't just federal regulations that they've adopted. They have also adopted many other pronouncements, including a compliance manual, which tells airport owners that have taken federal money how they have to comply with their grant conditions. More on that in a minute. All I want you to remember for now is, along with the federal regulations, there are other directives adopted by the FAA that have the force of federal law. And then on top of the things they've promulgated, the FAA, like most administrative agencies, has quasi-judicial powers too. So it conducts hearings. If there is a dispute about what an airport owner like ourselves can do, usually that dispute goes first into the FAA's quasi-judicial regulatory system. And there are 3 levels of review. Ultimately, there is a hearing. As many of you in the room know, that's the route that the challenge to the C&D ban took through the FAA and from thence into federal court. So the FAA treats all of its regulations, directives, all of them as federal law, and of course takes the position that they all must be followed. Moreover, as all administrative agencies do, it takes the position that they must be followed as they are interpreted by the FAA. So under federal law, the agency has the power to establish the rules, and then it also gets to interpret the rules and federal court defers to the agency interpretation. That's a general precept of administrative law. That's true across the board, not just for the FAA. Let me move on. So now I'm going to move on to agreements. But before I leave there to review, so we have federal statutes, federal regulations, other directives issued by the FAA. We have agency decisions, which create precedent, and then we also have court decisions that, for instance, go partway to defining what proprietary rights in airports are and aren't. Now let me move on, because in Santa Monica we also have what amounts to 3, at least, contractual agreements with the federal government. And along with federal law, those contractual agreements limit what the city can do or can't do, at least at certain points in time, with respect to the airport. The oldest of those is what we call the instrument of transfer. Now, a number of the emails that I got in the last couple of weeks had to do with the instrument of transfer. A couple of you weighed in and said it's really important that you explain to the public what that is. And to do that, I want to go sideways for a moment. So we prepared this partial history of the Santa Monica Airport, kind of as a listing, sort of an informal timeline. I want to thank Airport Services Director Bob Trimborn and Rod Merle and Ivan for their help on that. I don't know if you've had the time or the inclination to look through it. One of the things that you'll see if you did is that the airport has a very long history. There's been a lot of controversy about it. This sort of informal timeline was not intended to be exhaustive, because had it been so, it would have been 50 pages long instead of 5 or 6. But I thought it was important to give you an overview. One of the highlights of that partial history is what happened around World War II. So the city's owned and operated the airport since the 20s. It's a very old general aviation airport. When World War II came, the city leased the airport that it owned and operated to the federal government for wartime uses. This was done mainly to protect Douglas aircraft at the time. But I'm sure the federal government may have made other uses of it as well. I think Douglas was the federal government's primary interest. I see Bob nodding, so that's probably correct. After the war was over, the federal government transferred the airport back to us. That was done in a couple of steps, but one of the steps was the instrument of transfer. The instrument of transfer is an agreement in a way that says, we'll give you this back, but subject to these conditions. Conditions that the FAA imposed included operating the airport without unjust discrimination or without the creation of exclusive rights. I want to pause on those terms, because those restrictions, those federal restrictions, come up again and again. They're in the federal regulations, they're in the instrument of transfer, they're in grant agreements, they're everywhere. Now, as all of you who are thinking about this would immediately realize the first time you heard those terms, unjust discrimination and exclusive rights are pretty vague. So you know right away that there's going to be a lot of law trying to sort out what that means and what it doesn't mean. And those of you who followed the airport and the FAA and our adventures with the FAA for years know immediately that the FAA will interpret those terms very broadly. And anyway, the war ends. A few years later, we get back the airport, and we get it back. We get a chunk of it back through the instrument of transfer. So that's what the instrument of transfer is, and the reason it's important in the discussions that are going on now in the community is it is one of the documents that contains restrictions about what we can do with our airport. So that's one of our 3 agreements. There is also the 1984 agreement. I was asked to tell you by one of the community members that the 84 agreement is not a lease. That is right, it is not a lease. We do not lease the airport, we own the airport. The 1984 agreement is a settlement document. It was created and executed to resolve ongoing disputes between the federal government and the city of Santa Monica about how to operate the airport, what could be done at the airport. I know there are a number of people in the audience who could probably virtually recite the 1984 agreement. For those of you who aren't that familiar with its terms, I'll just say that it includes a promise by the city to operate the airport until 2015. It also includes a number of operational restrictions. I have been asked to also say whether those operational restrictions will remain in place once the 84 agreement expires in 2015. The significant operational restrictions were all incorporated into our municipal code, and they were incorporated into our municipal code before the Airport Noise and Capacity Act was adopted. So we had the power to adopt them, something we no longer have without going through an extensive federal process. And so the answer is yes, they will remain in effect after 2015. So to orient you again for where we are, I'm running through the contractual agreements, or things that are like contracts that we have with the federal government. The third of them is the grant assurances. Allows the FAA to make grants to airport owners to make improvements on airports. And over time, the city has accepted a number of those grants. With the grants come conditions. And the conditions include, yes, you guessed it, a promise that we won't engage in unjust discrimination or the creation of exclusive rights. The grant assurances, those promises by the city made in exchange for federal dollars, run for 20 years. The last grant that the city accepted, we believe, was accepted in 1995, and so it expires in 2015. I was asked to highlight this by members of the community as well, because this is a point of dispute between the city and the FAA. The city believes that 1995 was the grant, 20 years, it's over in 2015. But the FAA says that our obligation to comply with the grant assurances actually expires in 2023. I was asked to explain the basis for that. The basis of that is that there was a truing up, I'll call it, on the 1995 grant. So the grant was to complete certain work that was agreed upon. When the work was done, the federal government owed us a small amount of money, and we received that money in 2003. The FAA now takes the position that the receipt of that money constituted a new grant, and so we can't, we are stuck with the grant assurances, or we are, bound by the grant assurances until 2023. So there is a dispute about when our obligation to comply with grant assurances expires. The city sees it one way, the FAA sees it another. So what do the city and the FAA agree upon? Well, we agree that the 84 agreement expires in 2015. We don't agree about what that means. The FAA believes that, as I said, the grant conditions don't expire until 2023. They also believe that the instrument of transfer, that 1948 document I mentioned earlier, that the instrument of transfer imposes upon the city a perpetual obligation to operate Santa Monica Airport. The city disputes that. We are very familiar with the FAA's legal positions because most of the disputes which I've mentioned in the last few minutes were all argued in the fight over the C&D ban. And so we have the FAA's briefing on these points. They know what our position is. We know what their position is. So I can say with some certainty what their position is, having heard it repeatedly for many years, and as recently as the last couple of weeks, discussed it with people in the FAA. Let me just take a couple more minutes to address a few other questions that I got from members of the public in the last few weeks, and then I'll be done. The first was, why don't we just close the airport? I'm sorry, I answered that one. The next was, why don't we just close flight schools? Because people associate flight schools, of course, with pattern flying, and pattern flying is viewed as a nuisance by those who live beneath the pattern. The FAA asserts that it may be a violation of the 84 agreement and the currently operative grant conditions to close flight schools. They believe that normal landlord-tenant law doesn't apply, and so that even if a flight school were on a month-to-month lease, we could not, without their permission, exercise the normal rights of a landlord to terminate a month-to-month lease on 30 days' notice. So there is a dispute about what authority we have with regard to flight schools, and therefore the FAA has encouraged us to look into what voluntary arrangements can be made with flight schools, and we are doing that, as the manager explained to you. Another question I've been asked in the last, I guess this is more like the last 6 weeks, was why doesn't the prohibition on patterned flying that's in the 84 agreement apply to all patterned flying that takes place at the airport. Probably everybody in this room knows what pattern flying is, but just in case you don't. So pattern flying is where a plane takes off, circles in the immediate vicinity, and then in some way or other touches ground again, and then takes off again. And there are a couple of reasons that would happen. That would happen because somebody was learning to fly, or it would happen because somebody who already knew how to fly was recertifying. Recertifying, which you have to do that. You have to qualify actually rather frequently to maintain a pilot's license. All right, so a little more. The 1984 agreement prohibits two kinds of pattern flying activities. It prohibits what's called a touch and go, where your wheels touch ground and you take off right away again. It also prohibits stop and go, where you touch down, stop, don't leave the runway, and take off again. But there's a third kind of pattern flying. That's called a taxi back. You land, you taxi back to the head into the runway, and then you go down the runway and take off again. The 84 agreement does not prohibit taxi backs, and we can't interpret it to prohibit taxi backs without a fight with the FAA, because they believe that those three types of operations are separate and distinct, and they believe that each one of them is an airport access issue. They interpret limitations on airport access, which means who can use the airport and how. They interpret those as subject to review under the unjust discrimination covenant. As I told you, they interpret their own regulations and the obligations that we have to them extremely broadly. But that is their interpretation about it. Moving on, another question that I've been asked is, why do other airports have other rules than we have, other rules that might be better for people who live near airports? One reason other airports have different rules than we have is that they adopted their rules at different times. The federal legislation that's been adopted over the decades since World War II has gotten, in some ways, more and more restrictive of our rights. And so the kind of noise restrictions that we have today that flow from the 84 agreement and are now in our municipal code could not be adopted today, nor indeed can they be amended today without going through a federal process to get federal approval. So there are other airports in the area that, for instance, may prohibit taxi backs, but if that's so, it's because they've prohibited taxi back operations for so long. But that's a general expression of why the rules are different at different airports. It depends on historically when they adopted the rules that they have. It could also depend on what fights they've had with the FAA, but more commonly it's the history of the airport and of airport regulation. Next, what is our proprietary authority exactly? Well, we don't know, for the reason that I said. I mean, we have a position about what our authority as airport proprietor is. That is a subject that's being settled slowly by the federal courts. There's a split between the federal appellate circuits on what proprietary rights cover. The only thing that everybody agrees about is that proprietors have the right to do something in the way of noise regulation. And I don't know if you know this, but Santa Monica actually has, in relative terms, very restrictive noise regulations. I know it seems funny to you, but if you look at the decibel limits at other airports, they are on paper more restrictive than other airports. All right, so it's unclear what rights are, and that is a dispute that we've already worked on for years with the FAA, and which I'm quite sure will come up again, because the extent of our powers is very, very important to us. Next, a question I was asked is, this is a big one. Let me do the smaller ones first and finish on a high note here. Another question I was asked is, why don't we just change the noise rules? For the reason I just said. The Airport Noise and Capacity Act doesn't allow us to just change noise rules at this point. We'd have to go through a federal process to do that. Very few cities, one that I know of for sure, one, has made its way through the ANCA process successfully. So it's not that it can't be done. It's just that it's a very, very long shot to get through that process. And then finally, I was asked the large question of, why does it appear that staff is so reluctant to argue in favor of closing the airport? Staff isn't reluctant to argue in favor of anything that council wants us to argue in favor for. I think those of you who've followed our controversies with the FAA for many years know that we're always willing to take on a fight if the council wants us to. But right now, it's very clear that the city does not have the authority to close the airport. We're under a promise to operate it, a promise we made to the federal government in 1984, which runs through 2015. So it's a moot point whether staff thinks we should close the airport right now or not. What is before the council tonight is a process that is intended to identify alternatives. It is not a process that's aimed at a particular result. It's a process that's there to figure out what the possibilities are. My own view as an attorney is that no matter what council's ultimate decision is, we will be better situated having gone through that process than if we didn't. So I hope that interpret the description of the process as evidence that staff is reluctant to do anything. I think anyone who knows the city manager and I know that we're not shy. So, and nor are the people who work with us. So if council makes a decision to pursue any particular plan, you can be assured that we will pursue it aggressively. So I think that concludes my presentation, and I'll be happy to answer questions later.